It came to us about 8 months ago. The United States of America, to the republic which it stands, one nation, under God.
So that it can be picked up by the video. So if you don't mind taking maybe 10-minute recess real quick, maybe 5 minutes, Mr. Boyd will fix the sound and we can move forward.
It starts at 32. It starts at 50, which is fine. I can fix it.
All right, commissioners, we'll be back in session. Commissioners, we have before us the approval of the minutes from our September 25th, 2025 meeting. Have you had a chance to review the minutes? Are they true and correct as presented, or are there any additions or corrections?
Mr. Chairman, there's one small typo, and it's hardly worth mentioning. Page 8, they just dropped an R off my name.
On which page, sir?
Page 8,
Page 8.
about 2/3 of the way down the page. I've been called way worse, but
I got it. And Mr. Pennington will see that that is corrected. Mr. Tingle is now Mr. Tingler. Are
I
there
don't
any-
know, does Mr. Tingle get paid more?
Just
And you do not get a double check.
Oh, man.
just make sure to include that in your motion when you approve the rest of the minutes.
Yes, sir. Commissioners, are there any further additions or corrections? Hearing none, is there a motion to approve the minutes as corrected?
Mr. Chairman, I make a motion that we approve the minutes
And
from
I will-
last month's meeting with the correction of Mr. Tingle to Tingler.
Second.
Motion by Mr. Young, seconded by Mr. Tingler. No further discussion. All those in favor signify by saying aye.
Aye.
All those opposed, nay. The ayes have it. Motion carries. The minutes are approved as amended. Mr. Pennington, we have two items on the agenda tonight, and public hearings are required. Would you be so kind as to read the protocol for the public hearings?
Thank you, Mr. Chairman. Purpose of a public hearing is for the Caroline County Planning Commission to listen carefully to the verbal expression, position, and opinion of citizens of Caroline County. Public hearings are not question and answer periods and debates, and all statements should be addressed to the chair. When members of the public offer comment, they need to clearly state their name and voting district prior to making their comments. Applicants or representatives of the applicant will be allowed, sorry, we don't have any applicants tonight. Persons speaking at public hearings are respectfully requested to keep comments brief, not to exceed 3 minutes, and to address only those issues pertinent to the matters addressed for public hearing.
Thank you, sir. All right, commissioners. SO 01-2025, an ordinance to amend the Caroline County subdivision ordinance. Who will be presenting that? Mr. Hughes.
Sure. Good evening, Mr. Chair and members of the commission. So at the August 28th meeting, 2025, the commission reviewed amendments to the zoning and subdivision ordinance that are required as a result of changes to the state code. Excuse me. The commission also discussed potential amendments to the requirements of creating parcels via the family division provision. The discussion, as directed by the Board of Supervisors, focused on potential amendments that have the intent of reducing opportunities for the family division provision to be abused and circumvented. The commission provided staff with some comments after two discussions here in this forum. Those ideas have been incorporated into the draft of the ordinance that you have, and along with those ideas, and the packet that you received contained the materials from the prior meetings. The one thing I do need to point out to you tonight is that at your places and on the screen tonight, you will see some amendments to the language that you received in your packet. Now, those amendments are not material to the ideas and the provisions that you guys requested. They are just to tighten up those provisions as we were kind of working through the ordinance and how it may function practically. We noticed some language items that needed to be cleaned up. So I will show you those tonight. And like I said, they're not material. They just essentially try to address some of those anomalies that could have potentially come up. So I don't have a clicker tonight. Okay. Yes. So we will start with definitions. The first change is to the definition of a bond. And as you can see, it's a certified check, cash, escrow, or letter of credit in the amount of the estimated cost of construction of facilities to be dedicated for public use within each section of the development and in a form approved by the county attorney. And so that language is updated. We have made some amendments to our bond forms. And so this just clarifies what types of sureties that we will accept for bonding purposes of public improvements. Then continuing on to page 2, the definition of immediate family has been amended. If you recall, the prior definition was pretty exhaustive and had all the provisions allowed by the Code of Virginia. And the amendment now, immediate family is now defined as any person who is natural or legally defined offspring, stepchild, spouse, sibling, grandchild, grandparent, or parent, omitting nieces and nephews from the definition there. Then continuing down under lot, we have added a definition for utility lot. This provision is being added because of the need sometime for even county utilities or other utility providers, excuse me, to have a lot specifically for any equipment or that they may have. And so that definition is a lot created to accommodate the installation or storage of public or private utility equipment and infrastructure either above or below ground. And so that's a new definition that we don't have. Moving on to page 3. The definition of family subdivision is added here. It's a single division of a lot or parcel for the purpose of sale or gift to a member of the immediate family of the property owner. And so we just previously talked about the definition. Thank you. And then also at the bottom, under the definition of minor subdivision, we have added and utility lots. So you see there at the bottom, and the reason we did that was so that there's a process for reviewing those utility lots when they come along. So they would be reviewed through the minor subdivision process. And then on page 4, this is a change that is directed by the Code of Virginia, and it speaks to the subdivision agent or director of planning, the person employed or otherwise authorized by the county board of supervisors. Let's see, I might be able to. Can you go back one, Craig? There we go. The person employed or otherwise authorized by the county to serve, enforce this ordinance, and review and act on subdivision plats, site plans, and plans of development governed by this ordinance. This person employed in this position or otherwise authorized by the county to serve in such position is designated by the board by virtue of the ordinance as the designated agent for this ordinance in accordance with the Code of Virginia as amended. And so that is a new definition there or a change to the definition. So moving on to section.
Sorry, Mr. Hughes. I had a
Mhm.
quick question.
Sure.
Sorry, I know we discussed this in length before, but something just occurred to me going over some of this new stuff, and it may be a question for our attorney. So we have a natural or legally defined offspring. That includes adopted children, right, in the Virginia Code. Okay, does the Virginia Code define stepchildren, what a legal stepchild is? Legal stepchild. Can't hear you, sorry. Well, we talked about it last time. I think, yeah, you might have been. Yeah, a stepchild, the parents have to be legally married and the child has to be a child of one of those two parents.
Correct. So the stepchild, I don't believe would be legal offspring of, unless explicitly included in the definition of the step parent. But if the parent of birth were an owner of the property, they would still qualify as legal offspring of one of the property owners.
As long as the child belonged to one of the
Property
parents,
owners.
correct?
Correct.
I'm
As-
just, I guess
as long as they
that's,
belong to one of the owners.
I guess that's how the Virginia Code's gonna define it. But we're not including, step sibling, step grandchildren, step grandparent, step parent, right? Just stepchild. Correct, Mr. Hughes? Okay. That's
That-
what I thought. I just wanted to,
Correct.
And
all right.
I have a question on that as well. I apologize because I wasn't here last time, but what in a situation of I raised the stepchild, but the wife and I are divorced? But the
Yeah, we
stepchild is
discussed
still
that last time. It's no longer your stepchild, your
No longer.
legal stepchild if you divorce. Yeah.
Okay. Thank you.
It can get tricky, right?
Once the marriage is dissolved, the stepchild or step-grandparent is also dissolved.
By the Code of Virginia, yeah.
No worries. Thank you for the clarification.
Okay, so moving on to section 3, administration and enforcement. So the changes here are largely due to the provisions or the changes in the Code of Virginia, but I would note that on page 1 of this section, in section 3-1.1, we have stricken all the language that referred to family provisions. That language was included in the ordinance before. It has now been stricken and will be in a subsequent section of the ordinance. Moving to page 3-2, under section 3.2, administrative authority. Again, these changes are largely due to the change in the code. And then under 3.4, we have the penalties sections have been added. An owner of property or land or any tract of land who subdivides that tract of land who violates any of the provisions of this ordinance shall be guilty of a misdemeanor punishable by a fine not less than $10 nor more than $250, and each day after the first during which such violation shall continue shall constitute a separate violation. And then the validity is added. It says, should any article, section, subsection, or provision of the subdivision ordinance be declared by a court as a court of competent jurisdiction to be invalid or unconstitutional, such decision shall not affect the validity or constitutionality of the subdivision ordinance as a whole, nor any part thereof other than that part so declared to be invalid or unconstitutional. So essentially, if you have an issue or a court has an issue with one section of the ordinance, it doesn't invalidate the entire ordinance. And then section 3.6 on page 3-3, repeal all ordinances or portions of the ordinance in conflict with this ordinance are hereby repealed to the extent of their conflict. So that's also new language. And as we continue moving along.
Mr. Hughes?
Yes, sir.
One quick question, maybe, Mr. Havlin, can answer this one. These would be civil penalties, correct?
Mhm.
Okay. And just for clarity in my mind, if a person commits a civil penalty or commits a civil tort, they go to court and a judge says, you are in violation and you are fined $10 for that violation. Every day thereafter, it snowballs. It continues to mount up for that $10 per day, I assume. Am I making it clear as mud?
Yeah, my understanding is each subsequent day is a new violation.
Correct.
Yes.
All right. But and looking at the verbiage, and each day after the first, it doesn't say first what? First of the month? Right.
$10, the next day it's $10 more.
Right, I understand. But the way maybe the way I'm reading it, it says after the first. It doesn't say first violation or first
first day.
finding of guilt, as it were.
I think it means the first day, but do you need to insert the word day there? And each day
Or if-
after the first day,
First finding of fault.
Right.
Or am I making too much of it?
I'm not an attorney. I think the attorneys wrote the language, so
So this, Brad just clarified, this language is currently in section 7 and it was just relocated to section 3.
Right.
So we have not changed anything within this that's been presented to you all. So if you all would like to make revisions to this language, you're welcome to do so. The each day after the first, I agree, could be probably clearer what that means. My interpretation would be each day after the first violation.
Or first finding of fault,
Right.
something to say the first of what?
first day of violation.
How often does common sense come into play with something like this?
Well, wait a minute,
'Cause I
you're talking
think
about
we
law
all-
now.
I know,
Yeah.
we all kind of agree after the first day of the violation,
Right.
but does it need to be specified so it doesn't give someone, a counterpart to yourself, the ability to dispute it?
Yes, I'm absolutely love clarification at any
thank you.
chance you can put it in there. So
I would say, I would just make the suggestion that it's after the first finding of fault or violation.
I agree with that. Should be clear. Somebody's gonna fight it.
Yeah.
Okay.
And
Could we insert?
in both sections.
Yes, sir, and it should be in both sections.
Right.
To make one coincide with the other.
well, the language from section 7 was removed and added to section 3.
Thank you.
So it
Okay.
would just be adding it to this section 3-4.
Alright.
So what language are we going?
was it first finding a fault?
It works for me.
That's what I heard. I mean,
Anyone else have a suggestion? We're wide open.
Mr. Flavin, how would you write it such that it would be less ambiguous?
Look at you using Caroline County words.
I try to find.
Well, there are two avenues of this. One is you've declared it to be a misdemeanor in this violation, which violations of general ordinances, localities are allowed to declare them to be misdemeanors, punishable as misdemeanors with fines up to a class 1. Everything in here is within that class 1 threshold. But a misdemeanor is prosecuted by going to court and getting a judge to say you have committed this violation. So you're going to have to go back every single time regardless. So whether you classify that next day as a subsequent violation and the day after that as a subsequent violation, you're going to have to go in to get a judge to tell someone they've violated it again and again and again. So practically speaking, I think once you have the first violation sort of found by the general district, you're moving into sort of an abatement situation or an injunction to say you've got to do something differently. So I think practically speaking, you're not going to see repeat subdivision ordinance violations that are prosecuted through this method. So it's really how, if you all want to classify and make it clear that each day is a violation, I would say, subsequent to the finding of a violation, it constitutes a separate offense. Or each day that it is found to have been a violation constitutes a separate offense. And that lets the judge determine it's happened 100 days in a row. I'm saying you can prove it's 100 days in a row. I'm giving you 100 days worth of fines.
Okay. Can
Yeah,
we
because you
copy and paste
can
your
time
working
frame
days?
Right.
in the wording of the charge, you can time frame from April the 1st to April 15th, for example.
Exactly. So if you all want to put in there that each separate day constitutes a separate violation and leave it at that, not put, after a certain period.
Yeah, I think each day constitutes a separate offense, we should cover it. But
Sounds
I'll
feasible.
defer to my companions.
I would
Wave agrees with, I'm good.
I would suggest that that's the commission's desire on its recommendation, that after the $250 end paren, there be a period, and then it could just say
Each
day during which such violation occurs shall constitute a separate violation.
I would agree with that, Max.
Very good. Thank you, sir.
All right, moving on to section 4. So the changes in section 4, again, are as a result of changes to the Code of Virginia. In the first paragraph, we changed the word certified to signed by the subdivision agent. And then at the bottom in section 4.5, necessary changes, again, struck the commission and then added subdivision agent. And then any change, erasure, or revision requiring an exception shall be granted in accordance with section 7-1. And we'll get to that section in a bit. So section 5 of the subdivision ordinance, the changes begin on page 5-2, where we, in 5-9, there we go. So there again, in 5-9, the reference to the planning commission is stricken, and then we added language, and an exception is granted in accordance with section 7-1. And then over on page 5-3, in section 5-16, again, adding language for an exception under section 7-1. And as we continue on to page 5-4, again in section 5-20.1 and 5-20.2, the exception allowance under section 7-1 is added. And then on page 5-6, We've added, stricken the commission language and then added only upon the recommendation of the Virginia Department of Transportation, allowing a lesser angle. It relates to a design criteria for streets and roads. And so just made it clear that that was a VDOT requirement or falls under the purview of VDOT. And then in 5-23.1, again, we removed the reference to the commission. And then continuing on page 5-8, in 527 and in 528, again, changes required by the code changes where we strike the commission and note the subdivision agent and cleaned up the typo there of the word meeting. And then on 5-32, here we have language here. I think in your packet, we had stricken the language regarding the land for public purposes, but we have put that back in and then removed the reference to the commission and just note subdividers of residential subdivisions may be required to set aside land for parks, playgrounds, schools, libraries, municipal buildings, and similar public or semi-public uses subject to the following regulations. And then continuing down into 5-32.3, again, remove reference to the commission and added shall be, corrected a numerical anomaly there in 5.32.4. And then again in 5-33, notice to the adjacent property. It now references any exception to the subdivision ordinance versus any major preliminary plat that's been stricken. And then also in 5-34, the reference to the preliminary plat is stricken, and again, it references an exception. And as we continue down to the next section, which is approval of plats, we have made an amendment here. Again, needed because of the code changes with the title of subdivision agent as the addition and a reduction in the number of copies that need to be submitted with a preliminary plat. And that is just a change that is allowed because of changes in processes and the way we do business. And I think that's a change that the business community should certainly appreciate because it will be less cost to produce copies of things that need to be submitted when they provide applications. Then in section 6-2, preliminary sketch, these changes are all necessitated by the changes in the Code of Virginia. And so as you can see, they essentially strike the commission and also reference the number of copies that should be submitted. And also, we also now have added a requirement for a digital copy to be provided. And so that is it's a common practice. And because we now have new software and then the department and the way we distribute plans, most things are now distributed digitally. And so now we just have a requirement that when they make application, they provide us with that digital copy as well. So there's still a need for some hard copies because some agencies still review via hard copies, but much of our stuff is routed electronically now. So at the bottom in 6-3, preliminary plat, we reduced the number of hard copies that are to be submitted. And we reference language from the code about the number of lots and the need for a preliminary plat. So if you have fewer than 50 lots, your submission of a preliminary plat is optional. And that is directly from the Code of Virginia. So many people still do it because it provides them, excuse me, from their perspective, some additional opportunity for vesting of those plats. But the Code of Virginia has made that an option for 50 or fewer lots. Then we jump over to 6-4, additional documents. Again, changes for the code in 6-4 and 6-5, where the commission has been deleted. And then section 2 under 6-5 procedure, the commission has been removed completely from the process, and it says preliminary plats are reviewed and deficiencies, corrections, or modifications identified as set forth in the Virginia Code 15.2 2260 as amended. So a direct reference to the Code of Virginia as it relates to the review and approval of preliminary plats. Then over in section 6-6, which starts on page 66 but carries over to page 67. Again, we've added some language for clarity. In item 2, we've added Roman numeral 2 there to say approval of the final plat as diligently pursued as it relates to submission. And then we also, in that prior paragraph, Craig, can you scroll up just a hair? Yeah, we made a correction into the in the ordinance. There was an incorrect reference there, so we've corrected that as well. So, and so under the block there, it talks about how many lots you have to show if you're not doing all of the lots. There's language here that relates to 3 years following such preliminary subdivision plat approval and upon 90 days written notice by the certified mail to the subdivider, the subdivision agent may receive or may revoke, such approval upon a specific finding of facts that the subdivider has not diligently pursued approval of the final plat. So that's language that we did not have in the ordinance previously. And then in section 6-7, as it relates to security for performance penalties, we've added the reference to a letter of credit of types of sureties that we will accept. Moving over to page 6-8 under item 4, again, the addition of the reference to letter of credit, the changes related to the code as to the subdivision agent, and then also non-receipt approval of an applicable state agency, or that language has been added because that reference was not there. And then at the bottom, I don't know if you guys want me to read that entire section, but it talks to reduction of the bond amounts that are allowed as the project moves forward. And so this language is essentially directly out of the Code of Virginia. And so if you want a moment to review that, you're certainly more than welcome to do that. Good. Okay. And then moving on to item 5, again, a reference to letter of credit, then some clarification of sections, ordinance sections, the references there. And as we move down under 6-8, again, removal of the commission, and then 6-9, the final plat. Again, a reduction in the number of copies that are to be submitted, and then the reference to the subdivision agent, the reference to approval in accordance with 15.2 2259, and then again those changes to subdivision agent as required by code. And then that continues on page 6-10 with the changes to subdivision agent, and under item 3, um, it just makes it clear that the final plat in all respects conform and contain all elements of a preliminary plat and/or. And so that's just a clarification of what should be on the final plat. So um, just so that they are consistent and in the review process, things are not overlooked. The next changes on further down the page, I'll just refer to the subdivision agent. And again, on page 6-11, removal of the commission or director of planning, and the term subdivision agent is added. Moving over to page 6-12, still under the final plat section. Here we added a item number 22, and this speaks to the recordation of easements on plats and making it clear that the recording of those easements, that there is no responsibility of the county, nor does it create any responsibility of the county to maintain or repair any land or structures within the easements that are dedicated on the plat. And that's important because a lot of times in subdivisions, there will be easements provided, and there may be drainage structures sometimes in those easements, and citizens see those, and they see that easement, and that easement's been dedicated, and they immediately think that somehow the county is responsible for repair of that structure or land area within those easements, and that's not the case.
Who would be responsible for repair and maintenance?
Uh, that's an interesting question. It just depends on
Thank you.
how the HOA documents are structured, the deeds, but they're typically not public easements or public infrastructure, and so it's usually up to those, oftentimes, are private property owners or the HOAs. So
Okay, thank you. As long as the county's not responsible.
county's not responsible, and we added this language because I can tell you I've had many conversations with property owners where there's been something to start to degrade after many years. This is usually a problem that crops up in that 25th year of the lifespan of a subdivision, where something has just started to erode or something has started to fail, and someone needs to make some maintenance, and they want to look to the county to make those improvements, and they say, well, it's in an easement, and so the county should be responsible for it. This language is just making it clear that the county is not responsible for those items and those easements. So in section 6-10, again, we make the references and the changes to subdivision agent.
Include a caveat that unless explicitly accepted by the county, because there are
Ye-
instances.
Yes. Yeah. Thank you.
So sorry, could you scroll back up one sec? Within this number 22, there are instances in which the county will accept maintenance obligations for utility infrastructure, etc. And so I would recommend that the commission include at the end of that, unless explicitly accepted by the county, because the county does have to accept those easements. So that still allows that process to happen.
Good idea. And what verbiage are we going with, Mr. Hughes?
Unless
You
unless
work it out,
explicitly accepted.
unless expressly,
Explicitly
explicitly.
accepted by the county.
That's at the end.
Yes. Okay.
Very good.
And then moving on in section 10, what is now item number 5. This just makes it clear that approved plats are valid for not less than 5 years, unless there's some time that was determined reasonable for different considerations of phasing in the development or something like that. So, and then you have the reference there to the Code of Virginia, where that language comes from. And then in section 7, I think you have this at your seats, because somehow this was omitted from your packet, but there we go.
I think so.
So this is essentially a title change and recognizes the removal of those items that are stricken. And we talked about those earlier where they got moved to section 3. And so previously, section 7 was titled effectual clauses. And upon advice of Mr. Halavin, we've retitled this section to exceptions, and then there's only section 7-1 under the exceptions. And as you recall, there were several references made previously to this section, and so this is the process for to follow if there's a hardship or some other need for an exception to a provision of this ordinance. And here, the commission is still involved. So if we have to have an exception to the ordinance, then it would come to the planning commission. So that was one thing that the changes in the code did not strike. So now moving on to, I think, what everyone is waiting for. So
Can I have one question about
Sure.
the exception? So the commission may authorize, they recommending or they approving it?
It says authorized. You're approving it.
Okay, so the commission can approve it, okay.
Yeah. So under section 8 exemptions, this is a new section, and this is where we have moved all of the provisions related to family subdivision provisions in the ordinance. We have made them exemptions from all the other provisions of the ordinance by creating them in this section of the ordinance. And so, as you can see, the new language here is what we discussed. It says where any family subdivision of land is proposed and before any permit for the erection of a structure shall be granted, the subdivider or his agent shall apply in writing to the subdivision agent for the approval of the family subdivision plat. The subdivision agent will approve a family subdivision subject to the following conditions. And I don't necessarily want to read every single one of these, but I will point out a few things because these are essentially the items that you guys had recommended before. But I do want to point out under F, well, I think I'll walk through these because they're pretty significant. So I'll walk through each one of them. So the minimum lot size for a family division lot shall be 2 acres. The lot area and other dimensional requirements shall be the same as that for a lot 2 acres, for a 2-acre lot in the RR2 zoning district. The parent tract shall maintain the minimum lot size required in the RP zoning district or half the size of the original lot size, whichever is less. The overall sketch plan showing the future proposed family division shall be provided. Common driveway entrances shall be utilized in accordance with section 5.20 of the subdivision ordinance. To be eligible to divide a parcel for a family member, their immediate family, the property owner must have owned the parcel for a minimum of 5 years prior to the proposed subdivision. Any division of land created as a family division shall not be voluntarily transferred for at least 10 years, except as provided in the exempt section of this ordinance. And then later on, we'll talk about some of those exemptions that could allow that transfer to occur. And those were things that you all had recommended. The creation of more than 3 lots requires the access drive for the lots to be constructed to the private road standard as defined in the subdivision ordinance. And I'll note there that our private road standard is essentially a VDOT standard, is the way that it's defined. In a 20-foot access drive must be constructed with a minimum of 6 inches of 21A gravel at the time of a building permit application for a residential use. Now, that is different than what you have in your packet because if you recall, we had some conversation that included language regarding compaction rate. And after a couple conversations with VDOT, it was recommended that we just remove that language because of there's not really a one size fits all compaction because of the different soil types and the different types of uses on those roads. And so VDOT just recommended that it be, you know, to remove that. And so that's what we've done. And we're going to insert there to make it clear which type of gravel is 21A is what we're going to insert. So 6 inches of 21A gravel, which is a standard driveway gravel.
Mr. Hughes, can I ask a question about 6 inches?
Sure.
Where did that number come from? Like, it seems pretty deep.
Well, 6 inches is typically the base that's used for road construction.
Okay. So a 20-foot driveway would 6 inches of gravel would cost the new homeowner pretty substantial amount of money, right?
It certainly could, yeah, depending on how long that driveway is. That's correct.
So the entire driveway need to be in compliance. Is that what we're saying?
Yes.
Again,
And
yeah.
and I will say, you know, the rationale there is that it would be of such at that depth, it would have some longevity and withstand, you know, time, traffic, the weather, and so the road would remain in a fair condition, hopefully.
Is there a different standard for if someone decided to put asphalt in?
Similar.
No,
Would
if they
still be
wanted to,
6 inches?
You have to have
That's
the
a lot
base,
of-
but you have to have a base.
You gotta
yeah.
put 6 inches underneath the asphalt before you. Okay.
Yeah.
Okay.
Yeah, you would still have to have the base.
There we go. That's the clarification I was looking for.
Mr. Hughes, I mean, again, apologize for me not being here last time, but I certainly see this as a restriction to a lot of individuals being able to comply with this. You know, if it were more than, you know, if it was like 5 lots or more, I would certainly consider or would like to see these restrictions in place. But especially in my district, you know, we have a lot of impoverished individuals, and that's a lot of money to consider for 3 houses going in. I don't know how we would fix that, because then if it was more than 3, if they put 3 in and they go back to add more, then they would have to go back and reconstruct that road. But I don't know how we could consider that. I don't know about you all's districts, but I know my district, you know, where then a lot of the individuals are not financially savvy enough. I won't say savvy, but financial enough to afford that.
Oh, well, when we discussed it last time, we have some issues right now with road runoff, you know, ruts, and so then you create some muddy spots where it runs off and into the watershed and different things. And actually we discussed, because it used to be 50-foot wide. We discussed that last time, but it's currently 20 and we decided to keep it at that.
So the travelway has to be 20 feet. And so you'll see in a minute, we're going to, there's
The
a provi-
right of way is
the
50.
yeah, the right of way has to be 50
Okay,
feet.
I got you.
This is purely the travelway. So later on, there's a provision that says you have the 50-foot access, but you don't have to have 50 feet of improvement. So, and
Yeah,
the rationale for that is that at some point out in the future, if there's ever a thought that this road, let's say at some point in
becomes
the
a,
future, they want to bring it to
VDOT
the state
takes it over.
system, that amount of right of way would be needed to bring it to the state system. So it's there. You don't have to go back and start to
Yeah.
try to ask individual owners for right of way, which, can be problematic.
Which was another reason we talked about the 6-inch bays, because, it's easier to bring it up to VDOT standards if something is there.
I certainly agree. I'm just thinking with 3 homes, that's a major expense. After 3, I would certainly say yes, then that would be something that needs to be considered, because that's a subdivision as far as I'm concerned after 3.
It is, I think, right now in the ordinance, but I
Up to
mean,
3
if all
would be a
3
private
lots
community.
would share the cost, probably.
Yeah, but that, at 3 lots, that would be almost like a private community as opposed to a subdivision. And that's relatively expensive for 3 individuals trying to fork out that kind of money, because you're gonna have 1 home there already. And then you're gonna add 2 more to that. I just don't.
Or one. Or one.
Or 1.
I think what would be done too is when the home was built, that price is usually, a driveway price is usually considered in your mortgage. So you usually don't have to fork the money up front.
Yeah, that's a driveway cost, and that'll
Still-
price you out of buying a house.
It still prices into the price of the house, though.
Yeah. That'll price you out of buying a house.
Yeah, I mean, I think it's a
know, and I
reasonable
mean-
request.
Yeah. And what if we were to get into situations where we would have Habitat and other individuals of that nature putting in homes?
You get a lot of donations.
You
for
don't get that many
though.
donations. I'm on the Habitat board, trust me. You don't get those kind of donations.
And most of the houses, I think, are generally close to the road. Not all of them, though.
You got a lot of farmland in my district. And
Yeah,
and
mine
so do
too.
you. So do you.
Yeah.
Yeah.
I mean, my house fell under all these rules that were much stricter 30 years ago. And my driveway's a mile. I just had to put it in with my mortgage.
I bet.
And I tend to share Mr. Young's concerns. I know when I built my house in Tennessee, I was 3/10 of a mile off the roadway and had to put gravel down. And that was in 2000, 25 years ago. So,
And
I share
upkeep.
your concern.
Yeah, and the
Yeah.
upkeep.
Oh, yeah.
The snow.
I don't think we're putting in
Have to,
upkeep, though,
you're
are we?
scraping snow, and you have to put gravel there yearly.
Show maps.
Oh, but we're not requiring upkeep, right? It just has
I
to
mean,
be.
it's going to have to be upkept.
Yeah, upkeep and maintenance is going to be in it, I believe.
Are we requiring
In that
upkeep?
maintenance agreement, though. So there is a provision that will require a road maintenance agreement. As you see, item J says a road maintenance agreement in a form approved by the county must be recorded that includes each proposed and any future parcels that may use the access drive. So there is
But that road maintenance doesn't necessarily say it must maintain 6 inches. Because it's gonna get compressed.
Probably would, though.
It's gonna get
Oh, it's going
compressed.
to definitely, get less.
It's
I mean,
going
my
to
mother
compact.
lives on.
I mean, because I don't think they're gonna be able to maintain 6 inches.
well, that
but
could be
that's the
maintained.
rule.
Yeah.
I don't think that's in it right now. It said you have to have a road maintenance agreement, but it doesn't say maintain 6 inches.
I mean, it would be saying, it's saying that it has to be maintained VDOT standard, correct?
No, because.
I mean, it doesn't say that here, but is that the implication?
No,
You said no.
I'm sorry, that was a inadvertent no.
So it does.
So yeah, the anticipation is that that road, at access drive, I shouldn't say road, that access drive would maintain 6 inches of gravel through the life of the road.
And it's just the access or the entire road?
It's the entire drive.
Right.
It's the access drive. Yes.
So what would you propose as a substitute to this?
I would certainly maybe consider the entrance for 3 houses, but anything beyond 3 houses, I would like to see it maintained by VDOT standards, or not maintained, but at least um, implement VDOT standards implemented going forward after. But at 3 properties, that's just a hardship on the individual.
What are you proposing instead for 3 properties?
Maybe just to maybe the entrance, have the entrance from the main road,
But
have that VDOT standard, but the roadway itself, yes, maybe 21A, but I'm not saying 6 inches of gravel.
so how many inches of gravel do you?
I don't know. 3, 4
So,
inches.
just for clarification, the entrance is going to be required anyway.
Correct.
So,
Okay. Yes.
because VDOT is going to require that
Correct.
because they're going to need a permit to
Yes.
create the access point to the road. If it's a new road,
Right. I just wanted that to be
Yeah.
stated. Yes.
And for what distance?
I mean, use this apron. I don't know what VDOT calls for apron. I don't know if it's 10 feet,
If you
15 feet.
a low volume entrance is a depth of 20 feet.
Okay.
22 feet.
Okay.
And it has some radii requirements on it, but that has to be paved. So there's a considerable expense just to put in that driveway.
It has to be paved? When did that change?
I think that's in the standard.
I don't think so. Mine's got approved. It wasn't paved. I mean, I paved it after the fact, but
Well, the low volume standard. So if you get to 3, then they're typically going to want to have.
yes. I'm sorry.
Yeah.
Okay, I'm with you. I'm thinking 1. My fault.
Right.
So my question still stands. What are you proposing I should say?
To prevent the hardship, I would say yes, we should at least do the entrance and have that VDOT standard. But up to 3 houses, I would say going forward, you probably would have 3 inches of gravel, 21A.
So just basically you're just reducing number 6 inches down to 3 inches.
Down to 3 inches.
Um,
And then that must be maintained.
unless,
3 homes or fewer, yes, 3 homes or fewer.
Okay.
Beyond 3, then they have to go in and do a VDOT standard, 6 inches or more with the base.
3, that's really small.
My mom lives on a private road, and I can tell you, Carol, that, and she's in Stafford County, and it's on a private road maintenance agreement, and they've never maintained any type of depth on her
Yeah,
road.
well-
You can see red clay driving down the road.
Yeah, we have roads like that in Caroline too. We're just trying to prevent that.
Mhm.
Those are all grandfathered.
I know, but somebody like my mom, I'm not saying JD's got a different client. I mean, if my 84-year-old mom had to do that, I mean, her driveway itself is probably 100 or so
Yeah.
feet.
Yeah, but
wide. That's
she's
a
not
lot
gonna
of
have
money.
change. She's grandfathered.
No,
What
no,
we're doing
we're
is
not-
talking about
but-
new
yeah, We're
houses.
not saying that, but
Yeah.
I'm just saying it's a hardship on anybody that's gonna 3 houses or less.
I mean, we have to maintain that over the life of the road maintenance agreement. At some point, you're gonna get below that
Yeah.
threshold of,
I mean, I'm willing to compromise. I think 3 is gonna cause some big problems,
Why?
but
I mean, 3 inches is still pretty deep. I mean, you're
It
talking
just-
like this deep.
because
for
I know,
6.
I mean, my driveway it was probably more than 6 inches of gravel, and it
How much would it cost to redo your driveway today by
Yeah.
standard?
well, for a mile, I had it redone, scraped and re-gravelled last year. It was $2,000.
Yeah, but you don't have that much traffic. You shouldn't have that much traffic with 3 houses or less, 3 or less.
Yeah, I got one house on my driveway.
And you don't do it every year.
No, but I'm saying that's how much it cost
True.
last year to
True.
redo it, $2,000, which.
But it wasn't 6 inches.
Yeah, I didn't get it already had a base of 6 inches. I just had it re-gravelled.
Okay.
I mean, I'm surprised it was that low, but that's and I had the middle scraped down, cause the middle keeps growing up. And then also you're gonna get ruts and stuff. I mean,
Yes.
I'm willing to go down to 3 inches, but I think that's really gonna cause a problem. We're gonna have to somebody's gonna have to address in the future.
Well, yeah, in the future, I mean, then it's a subdivision.
Yeah, but some people are not gonna maintain.
Okay, if they want to, I
Yeah.
mean, one, the county has to enforce it for one. Two, if they want to tear up their vehicles and go through mud and all of that kind of stuff, that's on them at that point. But the county will enforce that. Correct?
Mm,
That's what it
That's what it's
yeah.
saying here.
Well, I
yeah.
mean, they're gonna try, but usually certain things like this, you don't enforce unless somebody complains, cause there's
Okay.
just gonna be so many of them. But I'm
But-
willing to compromise down to 3,
Well, I
but
appreciate what you're saying.
I think it's just gonna cause issues.
But what would be the problem if it's not maintained?
Well, like I said before, the ruts, the runoff,
But what would
Well,
that? I mean, but what will that cause us as a county?
Nothing.
it can run into the neighbors, yeah.
Okay, but that's family.
And, you know, the Chesapeake Bay Act gets violated, things like that.
No, it's no difference than driving across the yard. I mean, it's gonna rain and you're gonna get water
Yeah,
on.
but not too many people drive across the yard, but some do.
No, I'm
Mine
just,
does.
no, I'm just saying, well, the water is still gonna be
Yeah.
falling, and
Yeah,
whether
but
it's in
for
the
the sake of
driveway-
moving forward, yeah, I'll agree with 3 inches. I just don't
Yeah.
think it's a good decision.
Okay, I'm not arguing. I'm
Yeah.
just trying to prove a point.
Mhm.
I'm not proving a point, but just say I just think it's a hardship on individuals. Everybody can't afford that, and if we're trying to give the opportunity of families being able to subdivide at a cheaper rate, then this is going to price them out the way we have it structured now. It's just going to, might as well move to Hanover County or somewhere else and build a home or buy a home.
It's strict everywhere.
No, I'm just
but,
saying.
But, yes, let's just move forward,
I
because I said
wouldn't-
I'd go down to 3 inches.
All I'm saying is, if my family owned the property, and I thought it would be cheaper for me to stay on my family's property and stay in Caroline County, but I got to pay this kind of money for a roadway, I might move to Hanover County, and I'm saying that will be a piece of property that I would already purchase, that I don't have to worry about subdividing. You with me? Or move somewhere else in Caroline without subdividing. Again, that's a hardship on individuals.
Yeah, anyway, you look at it, it's
The
gonna
way
be a
you,
hardship, yeah.
right. So I'm saying if we can eliminate some of the hardship by the family subdivision, I think that to me, that's the reason it's
Yeah.
there,
Yeah,
to be able to afford the opportunities for generations to come.
yeah. Well, I think one reason we're tightening up too, though, is a lot of people doing it just so that they can sell the land after they've had it a little while.
But we put those provisions in place. Yeah.
Well, that's what we're trying to do now.
Right,
Yeah.
but it's still a capitalist country. So if they want to sell it at a later time, certainly. you know.
Yeah, it's gonna be 10 years now.
Yeah, 10, that's fine. We have that in place. So if they want to wait 10 years and don't do any improvements, how can we hold them to that? You can't force somebody to keep a piece of property.
Can I get clarification on, so the 20-foot access drive? So are we saying, all right, so I have 100 acres of land, I'd subdivide it and give 2 of my children 25 acres each, and they build homes within that 100 acres. So are we saying if the driveway is gonna be 1,000 feet from the highway, is the whole 1,000 feet gotta be 6 inches, or just 20 feet
20
from the
feet.
highway?
I was suggesting
The whole
20 feet.
1,000 feet.
The whole 1,000 feet had to be.
That's what it's saying now.
This is saying.
That's what it's saying now. I'm suggesting that the entrance,
The apron.
the apron of 22 feet.
Be
And then-
6
and
inches.
then everything
And then he
beyond
wants
that
it
be
3
great.
inches after that.
Yes.
So we also have in there where that's gonna be a 50-foot right of way.
Well, the right of way has to be there.
Okay, And I was just trying to encompass the 50-foot, if there was 1,000 feet driveway and you did the 6 inches up to the 50 feet.
No,
right?
you wouldn't do that.
Can't do that.
No, you wouldn't do that. Your road would be at least 20, and then you have 15 feet of easement on each side.
Okay.
So that's where your 50 would come in.
Okay, got you. Okay. All right, so it would be the total 1,000 feet if it was a 100-acre parcel.
Yeah, 1,000 by the 20, by 20.
A lot of dough, Joe.
So just
Yes, sir.
2 points of clarification. So a 1,000-foot,
1,000-foot driveway, 20-foot wide, 16 deep, would be $60,000.
yeah. A 1,000-foot driveway, 20 feet wide with 6 inches of stone would be $60,000.
Right.
That's your cost for that.
That's your cost. And you're putting up a $200,000 home for Habitat, it won't work. The numbers won't work. You putting up a $300,000 or $400,000 home, and you adding $60,000 to it. That's a hardship on anybody and everybody.
I mean, and the average cost of a home in Caroline County is somewhere in the threes,
Right.
minimally.
And I understand you're talking about sharing it with 3 different individuals, but the first one in,
It's still $20,000 each.
exactly. No, it's 30,000 each, because you only have one
Oh,
home.
yeah.
I did have one other piece of information I wanted to share based on a comment that Dr. Horton made regarding the abuse of the family provision in Caroline. So we looked at the family divisions between the years 2015 and 2020. And in that time period, there were 73 family divisions. There were 84 lots created out of those divisions. 70 of those 84 lots are still owned by the family. There were 14 transfers total, and that includes transfers after the holding period. There was one transfer before the holding period. There was two parent parcels sold, and then there are 5 that were not clear on if it's still in the family name or not. So, 83% of the lots that were created via the family division from 2015 to 2020 are still owned by the family. And 17% were transferred. So 14 transfers and 17%. And one of those transfers was due to a hardship. So individual came to the board, asked for an exception because of an extenuating family circumstance, and the board granted an allowance for a transfer. So
But that's hindsight. I mean, we're trying to prevent future things because perspectives are changing, So,
Right.
but I'm glad, we've got that. What'd you say, about 80%, 83% still in?
still on, yes.
Yeah.
Mhm.
But things are coming down the road from Northern Virginia's problem.
I mean, but if you got the 10-year period in there, even folks coming down from
Yeah.
Northern Virginia, they have to hold.
Well,
the
that's why
property
we're
for 10
moving
years.
it up to 10 years.
I agree
Yeah.
with that wholeheartedly. Yes.
Most of us will be dead.
Yeah. But again, those that already own property and would like to, I still look at individuals, children wanting to come back to Caroline. Right now, we're pushing people away from Caroline in every kind of way, with the job markets or lack thereof, as well as if my family owns property and my children don't have a place to stay, they're going to go somewhere else. I would love for them to come back here and afford the opportunities of being able to be here. Our teachers, our fire, EMS, we're pushing people away, and it's hard. It's hard for us as a county to survive.
So the other thing I'll share, you guys mentioned, so this comes from this data is from the Fredericksburg Area Realtors Association. That the median home price in Carolina right now is $405,000.
Yeah.
And that's a 13% increase compared to the same time period of last year.
And a teacher at $60,000 can't do that,
And so,
or a firefighter.
I mean, they can't even get teachers, firefighters, and policemen to buy the Habitat houses
Right.
that they're building because they're priced out of the market.
Houses are pretty high. But at the same time, we gotta keep the perspective that they're asking us to keep Caroline rural. You know, citizens don't, I mean, we have a big crowd in here every time there's some big industry wants to come in, like a data center, so
Yeah, but that's.
it's a
again,
balance.
Yeah, it is a balance, but those areas are already created for certain things. I mean, we're not trying to, we're talking about family subdivisions with people that own.
But you were talking about
large-
lack of jobs and
Well, it
things
is, I'm
like
saying
that.
like a
Yeah.
job, but I'm saying
Yeah,
that
because
goes
we
to the-
don't approve everything that comes
True.
in.
But again, those large parcels of land, if our children can't come back to those properties, they going somewhere else.
Yeah,
So I'm saying we should allow them to at least an
Accommodate.
opportunity to be able to do that.
Is there some opportunity with accessory dwelling units to allow for something like that that doesn't require a family subdivision or?
I don't know. Good point.
so we do have provisions in our ordinance right now for accessory dwelling units. So there are a couple options. Yeah.
That question may be
so,
outside the scope.
so
of
we
what we're
wanna go down to
here.
3?
So, well, just to answer Mr. Tingler's question, currently in the RP zoning district, you can do a family apartment where you can add a second dwelling unit onto your property that's limited to 1,000 square feet of living space. So it's basically a single wide. It must be rented to an immediate family member for the first 3 years, and then it can be rented to anyone after that. And then also there's provisions in Ladysmith Village that would allow for accessory dwelling units. I just did the family part. Oh, and there's also medical hardship where you could put a second dwelling unit on your property, but that part of the ordinance says that it must be removed once the medical hardship is relieved or the person passes away.
So a non-permanent structure.
That's the family apartment. I'm sorry,
So
could
a
you repeat it?
non-permanent structure in that regard.
Yeah,
Okay.
but those are the only accessory dwelling units in the ordinance right now, correct? Yes.
But we do have some provisions that allow us to put a granny pod on
Yes.
property, for instance.
May I make a
Less than 1,000
suggestion that
square
we
feet.
stay on point
Yeah,
with
I'm
the
way off topic.
driveway,
Sorry.
please?
Yep.
Thank you.
Yeah, I don't think we've talked about that long enough. I mean, if the majority want 3 inches. I think I said that several times, so.
Can we change it to 3?
Mhm.
Please and
Is
thank
that
you.
what the majority
Up to
wants?
3 houses. 3 houses or less.
Yeah, there you go.
So, okay, what happens if you get to the fourth house? What do you want to do?
That's when
Then it-
that's when they need to go in and start from the apron and move forward and put 6 inches of base in there.
Then we need to put that verbiage in.
In there.
in there.
Okay.
Because it's truly a subdivision at that point. Or a small subdivision.
Small.
Yeah.
Is it based on the houses or the number of
Yeah,
lots?
just-
Max.
Clarify whether they want
There
that to
you
be
go.
in replacement of H,
That's a good question.
because that's what the
Houses
zoning
or
law is right
lots?
now.
I would say
Oh,
houses.
I would say houses because they may not build on
May
it.
not,
for-
may not build.
Okay.
it. Yeah.
I'm perfectly fine with that. I just want to make it clear that.
So just clarification, if you look at H, right now it says if you create 3 or more lots, you have to do the private road. So are you gonna replace H?
So H already covers That's what you're saying.
That's even a higher standard though. H is if you get to 3 lots, you have to build a private road. What I understand now is you're proposing that if you go to 3, you go 6 inches of 21A.
No, the distinction is lots versus houses. This is more than 3 lots, so it'd be the 4th lot would require the private road. But what Mr. Young was talking about was if there are 3 houses, you can build the road to a slightly lower standard. That 4th house starts, now everybody has to upgrade.
Well, just for clarification, when you do a family division, you're creating a lot. So you're not creating a family division for a house. So it's a lot, I think.
Okay, so if we create the lot and the lot is never built on,
Just never built.
okay. Now that's a major hardship, right?
Um,
I mean, because that person is just now throwing money away for the most part.
No, you wouldn't make the improvement until you came and got a building permit. So
You make the improvement when you get the permit.
Yes, it says
Okay.
at the time of a building permit application for a residential use.
Okay, so we
Right.
can approve the lots and nothing has to be done until
Until they come apply for a building permit for that
that's,
house.
okay, that's what we were just talking about.
Because the other distinction is every family division lot isn't necessarily going to have a residential structure on it.
Correct. Okay.
So we're saying now that for I versus us saying when it gets past 3 houses, it doesn't revert back to the 6 inches. It goes to the private road standard.
Well, that's the way it reads right now. That's what my question. If you change I to 3 lots, what do you want to do with H? Because
Well,
H
that already
says
says 4 though, right? Basically, it says more than 3, which would be 4. So I think we can leave H alone, G.
So the only thing we need to change in I is if we want to go 3 inches, just change 6 to 3 and leave and don't do anything about number because H is going to take care of that
no.
after the 3rd
Okay, so
house.
what we could do, we could change H to read the creation of 4 or more lots rather than more than 3.
Same thing.
Same thing.
It
Verbal
Yeah, that's the same.
gymnastics.
Yeah, but work comp had the same problem a few years ago. More than 2 is now the language that they use because it was 3 or more. They got in some really weird language with it, and it caused problems with the understanding if you were right on that number. But if you say 4 or more, there's no
dispute.
Right, I understand what you're saying, Lee.
the original language was 3 or more. 3 or more employees, which created the problem. Was it 3 or is it more than 3?
Well, I mean, we could ask the attorney, is that good language for H? What we want to say is 3 inches, past the entranceway.
But
Yeah.
3 or less.
No,
And
actually,
then
just change
H
it to
is
3.
going to say, once you get to more than 3, you're
4
going
or
to
more.
have to do private standard road.
4 or more.
Because 3 is ambiguous.
Which it shouldn't be. Common sense says more than 3 is 4, but
3.5.
sure, right. So,
3
yeah,
3 in a
I know.
mobile home.
Yeah.
Right.
Right. Or something. Yeah.
An accessory dwelling unit that I completely wobbled on.
My mother-in-law's.
It sounds like it does to me. That's why I asked the attorney.
Go with 3 inches.
Because I mean, if you bring a mobile home in there, it's not
It's not a
considered.
Yeah,
canal.
more
it's
than
not.
3.
It's on wheels. It can move anytime it wants.
So you gotta
Yeah.
worry about building up to 6 inches. I know how you do.
Yeah. So, I mean, it sounds good to me, but,
Mr. Chair. Mr. Chair,
Sir,
may I make a suggestion?
yes, sir.
So our suggestion is that we close, go through the ordinance, close the public hearing, and let's massage this issue because we've just been talking about some nuances of divisions that, we're afraid that we might overlook trying to do this on the fly tonight. So,
Okay,
Certainly agree.
um,
I agree.
we can go through the remainder of the document, close the public hearing, and bring it back to the next hearing meeting and dispose of it and hopefully have some resolution to these two particular items and get it to a point that everyone's happy and we're not concerned that we created something to an unintended consequence or overlooked something because there are lots of nuances related to family divisions that we'd like an opportunity to discuss before we take it forward and have to.
Understood.
Yeah.
So we will continue on with the reading of the document.
And we won't, if it's not that much a change, we won't need another public hearing?
You're going to close the public hearing, correct? Yeah.
Okay.
Yeah.
All right,
After we finish reading the.
all right.
Yeah, after we finish
That's-
going through
Yeah.
all the document, yep, and we'll just close the public hearing, put off the vote, make some adjustments and hear your all's ideas, and then come back with those in a fashion we feel comfortable with, and then take the vote at the
And
next
then I
meeting.
haven't even officially opened the public hearing as yet.
Right.
So,
So the other thing is, and I'm separating because we remember we have another portion coming, so the zoning portion can go on its own and just be a separate item. So
all right, sir. So
Going to K.
so
you're suggesting that we go ahead and officially open the public hearing?
Yeah.
Continue on with the document, then close the public hearing? Is that what I'm hearing?
I would say let us finish through the
Finish the
document, open the public hearing.
Okay.
Close the public
That
hearing.
would make more sense.
Yeah.
Thank you, sir.
Okay.
All right, let's continue on then.
All right.
Okay.
Okay. Each lot must be served by an access easement that shall be a minimum of 50 feet in width. And so there again, this is just the easement width. That 20-foot drive aisle that we've been talking about will be within that 50 feet. And so L, the deed shall include a covenant that prevents the transfer of the parcel prior to the 10-year holding period. M, a family subdivision lot may be transferred in the cases of death of the grantee or a court order. N, a notarized affidavit affirming the immediate family relationship shall accompany each application. And O, which is also in another part of the ordinance, if the board finds that an extraordinary hardship is caused by the 10-year restriction, it may reduce the time period to alleviate the hardship. This hardship provision shall be noted on the plat or in the deed. And so when I gave you the numbers on the family divisions that have been created and transferred, one of those transfers was a result of an unusual family circumstance, and the board was able to grant that. And so this is I think a reasonable off ramp in those odd situations that are going to occur. I mean, we can't know what they are. I think in that instance, there was the recipient just could no longer, for various reasons, own the land, and it would have had to go to a tax sale. And the family, rather than have that happen, petition to get the land back so it would stay within the family and not be sold off. So, and the board felt that was an extenuating circumstance, and they granted it. So that has happened, I think, one time since you've been here. Yeah, so it doesn't occur often, but like I say, it is an option.
Just I wanted to note also on that similar type of provision, what's in your section 7.1 for the exceptions, that process would still apply for someone to ask for an exception to the family subdivision requirements. So in an unusual circumstance where they wanted to put someone on the river and that was 2,000 feet away of driveway, the commission would still have the authority to grant an exception to this 3-inch, 4-inch, whatever driveway requirement on a case-by-case basis.
Thank you, sir.
Question, Mr. Hughes. In L,
Mhm.
is there significance of the asterisk?
I was
at the
just
end?
gonna ask the same thing.
Yeah, I had that also.
I think it was just left over from our drafting.
Okay.
Okay.
So-
Yeah, I saw it. And I was like, why is that asterisk there? And I just remembered.
Okay.
So we remove that.
Yeah.
All right.
Quick question, Ms. Hughes.
Yes.
Once the grantor receives permission from the board and the grantee becomes the official new owner, how long what time period before the deed has to be recorded? From the time of approval?
So a family subdivision must be, the plat and the deed must be recorded within 6 months of us stamping it approved, or it's void and they must go through the process again.
Okay, thank you. That was my question.
I think that's it.
I have a question when we get to the end. Let's.
Okay. So the last item. So in this section, we've also added the utility lot, the provision for the utility lots. And as it says, approval of a utility lot requires review and approval from the county, state, and federal agencies as deemed necessary by the subdivision agent prior to recordation. And
That's it.
this is what I want to, hey man. So I just wanted to clarify, in the definition of the minor subdivision, we clarify the process for the utility lots. So I just want to be sure we didn't have to need language here to ensure the process that the utility lots would go through. So you just can't willy-nilly come in and say, oh, I'm creating a utility lot. There is a process that's in the definition that outlines how they will be created. So
Okay, very good. Any further questions by the commissioners?
Yeah, quick question. So, and this might be something attorney has to answer again. So in no way does the language in F conflict with the language in G? Because in one, I mean, it seems clear to me, but I don't know if there's a loophole there, because in one, it says, so in order to subdivide, you got to own it for at least 5 years, correct? But what we're saying in G is you got to own it 10 years before we transfer it.
Right.
So those don't conflict in any way, right?
Correct. There's a ownership period in order to be eligible to family subdivide.
Yeah.
And then for the people who are granted the property, they have a 10-year ownership period after that before they can sell the property.
Okay.
So it's the, property.
Yeah, but the property owner, see, suppose I get a lot
Mhm.
transferred to me. Do I have to keep it 5 years or 10 years before I subdivide again?
You have to keep it 10 years before you sell it to a
But 5 years before I subdivide.
you could do a family subdivision
Yeah.
in 5 years, but you could not voluntarily transfer to a non-family member for 10 years.
Okay. All right. So we don't need any specification that says non-family member. It's clear. You're thinking both those are clear.
If it could be clarified that the 10-year holding period doesn't prevent someone from family subdividing under this section. That would clarify if that's the,
Do we need that, or is it clear? I mean, would it be clear in a court of law as it reads right now?
I would clarify it in the
Okay.
ordinance. If you if you want the policy of the county, if your recommendation would be that someone be able to family subdivide after owning for 5 years, I would clarify that within the ordinance.
Okay, so we need to change then F or G, or both?
I would change G
That's
to
what I'm
create,
thinking.
yeah, an exception for going through the process in section 8-1.
So how would we word that? Anybody got any suggestions? You have a suggestion, Mr. Attorney?
Well, actually, it's already built in there now that I'm reading it again,
Okay,
because it says except as provided in the except section of this ordinance. And
so that clears it up. That's what I was kind of asking.
Yeah.
Is the words we're using here clear?
yep, that would, I don't know if you agree,
Yeah,
Leon, but I
attorney
think
word, so it's clear.
by referencing section 8 within that subsection G, it would capture family subdivisions as an exception to the 10-year holding period.
Okay. Thank you.
Any further questions by the commissioners? If not, Mr. Hughes, I'm going to open the public hearing. Public hearing regarding SO 01-2025 is now open. Is there anyone wishing to speak regarding this matter? Anyone wishing to speak regarding this matter? Final call, anyone wishing to speak? Seeing no one coming forward, the public hearing is now closed. All right, commissioners. We need a motion regarding subdivision ordinance 01-2025.
All right, since some of the wording's gonna be changed a little, do we have to defer, or is it not that much being changed?
Well, like we talked about, we want to be sure that we get the language correct related to the access, the gravel, and so what we talked about before was defer until the next meeting, and so that we can have an opportunity to work through the language and be sure we don't, create any unintended consequences by trying to do it here on the fly. So
That's what I thought, defer.
yeah.
You want to make it or shall I?
I can make it, well,
Okay.
I'm trying to. Which one of these is it?
Hey, you can use, I think you use this one right there.
That's what I was
The
thinking.
wording is
And
essentially
we're,
the same.
what's the number again? I'm looking for the number.
SO 01-2025.
01/2025.
Correct.
So whereas the general welfare and good zoning practice warrants, I move to defer SO 01/2025 to the next regular meeting for further discussion.
Second.
Motion by Dr. Horton, seconded by
it's yours.
Mr. Tingler. Any further discussion? There being no further discussion, all those in favor signify by saying aye.
Aye.
All those opposed, nay. The ayes have it. Motion carries. This matter will be deferred for further discussion to our next regular meeting. Thank you, one and all. Mr. Hughes, are you going to be the presenter on, well, I'll tell you what. Let's take about a 10-minute break. We'll be in recess for 10 minutes. All right, the meeting will come back to order, please. Text Amendment 03-2025. Presenter.
Good evening, Mr. Chair, members of the commission. So, as I noted earlier, the commission granted authorization to make these amendments in accordance with the changes to the Code of Virginia that became effective on July 1, 2025. A number of the code changes pertain to the review and approval of site development plans. The commission also discussed other amendments that we just talked about for the family division. And this item is to address those changes that include definitions and some additional provisions through the site plan process. Two housekeeping notes that I want to make before we get into this, and it's earnest. I'm not sure if it's in your packet, but I believe it is. The definition that I'm looking at and the one that's on the screen does not match the definition that we had in the subdivision ordinance. And the difference is that, and this is the holistic definition of as allowed by the state code. So that's the first thing we will make this amendment so that it matches the definition that is in the subdivision ordinance. So it would essentially just read family members, immediate family members shall include grandmother, mother, father, son, daughter, and stepchild.
And that does not invalidate our proposed.
No,
Okay.
no. We think this is a Scribner's error for some point. And the other housekeeping item we have is as a result of this changes to the state code, the site plan or the zoning ordinance also needs to make reference to a designated agent. And so we have a couple of definitions in our ordinance right now for administrator. And so we just need to add the language that makes it clear who the designated agent is as it pertains to the zoning ordinance. So it's the exact same language that we changed in the subdivision ordinance also needs to be in the zoning ordinance. And so with that, I'll move to the new definition we added as utility lot. And then, as you can see, a lot created to accommodate the installation and storage of public or private utility equipment and infrastructure either above or below ground. And then we move down to site plan. And under site plan, we have amended those definitions to talk about at first a plan building addition. No, site plan building addition is a plan for modifications to an existing building or structure that disturbs less than 2,500 square feet and does not require amendments to parking, landscaping, or the extension of public water or sewer lines, and may be completed with approval of building plans, zoning use approval, and meeting the Chesapeake Bay water quality standards. And so, like I talked about before, there's no provision in our ordinance that would allow someone to come in and do a simple addition to a building without having to go through the full site plan process right now. And so this will allow that to occur under these parameters. The other addition is a site plan linear trail. It is a site plan for land disturbance of equal to or greater than 2,500 square feet, exclusively for trail construction. The plan that includes parking or accessory structure shall be submitted as a site plan, major or minor. And so that's one of those provisions that doesn't occur often, but it does occur, and the ordinance didn't have a way to deal with it. Then we also have an infrastructure site plan, which is a plan that demonstrates that all the required infrastructure is feasible within a proposed project that shows the location of all property lines, topography, monuments, and the possible location of rights of way, water and sewer lines, and vehicle and pedestrian access. And so this is it simply as it sounds. It's an infrastructure plan. So wouldn't necessarily show any of the physical above ground features or buildings on the particular plan. We also add a site plan major, is a plan of development, redevelopment, or accessory structures where the land disturbance is equal to or greater than 10,000 square feet. And then we have a site plan minor, is a plan for development, redevelopment, or accessory structures where one, the land disturbance is equal to or greater than 2,500 square feet, but less than 10,000 square feet. Or two, the plan proposes modification to public water and sewer lines, access onto a public right of way, or the creation of parking areas. And so this will give our development community a lot more flexibility in terms of how they may approach the particular development projects that come along within those scopes. So we see those as good things. The next changes don't occur until we get over to section 12. No, I'm sorry. There is a change prior to that in section 7. It's a minor change under section 7(3). Actually, it's in 7(6)(f), and it just removes the planning commission from approval of the buffer zone requirements. And that's on the last page before section 12. So if you go to section 12, at the top of the page, you can see, if you look back one page, this is where that change is.
All right,
It-
Mr. Hughes, before we
Mhm.
go further, could I just digress a little bit to
Sure.
section 7, item 1? The minimum area for each manufactured home park shall be 20 acres.
Mhm.
The maximum number of manufactured home units permitted in any one manufactured home park shall be 150. Now, if someone had a 20-acre piece of land that they wanted to make a mobile home park, would they be allowed to put 150 units on it? Because that means that each unit would have 0.13 acres.
Mhm.
So if you've got a neighbor that wants to borrow a cup of sugar, you just hand it out the window, basically.
I mean, if you look at mobile home parks, I mean, they're on pretty small lots.
Yeah.
I mean, those lots are not very big at all. And this is not a by right use in the county. I mean, so you have to go through a process to get a mobile home park. So,
Okay. So,
but you are correct. I mean, they would be fairly densely sited.
yes, sir. And section 6, item F, reasonable fencing. Do we have it defined somewhere? And I'm sure that we do. What is reasonable fencing and who makes that determination?
I don't think we have a definition of reasonable fencing, and that determination would ultimately probably be made by myself, and I think it would just depend on the individual circumstance. I mean, what's on the adjacent property, you know, would be is a 3-foot high fence reasonable if you had some use that could be potentially dangerous on the other side, you know, probably not.
And I realize we cannot define and specify everything in the book under the sun. So if someone came to us with a project, we still have proffers.
It's got to go through
other
a process.
ways.
Yes. Yeah.
Thank you.
But I'm glad you recognize some of the issues that we have to deal with on a daily basis. So.
We do read these. Well, I'm sorry.
So in section 12, special provisions applicable to residential, the R3 district, We have stricken the subdivision of land within the R3 district shall be subject to planning commission review and approval. There again, that's as a result of the state code changes. And then our next change, which essentially renumbers that section of the ordinance. Then our next change is over in section 14, site plan requirements, and it jumps down to item 15, where it notes the number of sets of plans and plats submitted for preliminary review shall be 6 with a digital version. And then in B, the number of sets submitted for final approval shall be 6. And as you can, it went from double-digit numbers of submissions down to single-digit number of submissions. So, then I'm also in the site plan section. We have added item 19 that explicitly identifies the stockpile requirements. As you may recall, the commission and the board, the commission recommended and then the board ultimately approved changes to the ENS section of the code, specifically regarding stockpiles, and created these provisions. We wanted to add them to the site plan checklist so that applicants would not overlook them as they prepare their site plan, and we, hopefully eliminate the need to make a comment because someone didn't look at another portion of the ordinance to find these requirements. So we bring them forward to make it explicit that if your plan is going to have a project is going to have a stockpile, these are the requirements that you have to meet related to stockpiles. And it talks about the proximity of stockpiles to some residential uses. It talks about the maximum slopes, indicate the proposed location on the plans. And so these are directly from the ENS ordinance. So, like I said, just an opportunity to make it more clear for applicants what the requirements are for their site plan submissions. So. And then in item section 18, special provisions applicable to manufacturing horticultural products. Again, we strike the zoning administrator there and make a note that additional mitigation may be required in accordance with Chapter 45 environmental regulations of the Caroline County Code. So this speaks to more to water quality impact assessments, and then there it is making a specific reference back to the environmental code to see what the requirements may be. Then we jump over to section 19, resource sensitive overlay district, and then under item 19.7, design standards, in 1C, we strike the reference to the planning commission, and it says this provision may be modified by the zoning administrator if it's in compliance with VDOT access management standards. And so this speaks to access standards, and so it's a VDOT. This is something that VDOT would comment on and would lead the discussion and the guidance relative to access. So. And as we turn over, still in section 19.7 under item 6, again, the removal of the planning commission reference, and then a note that additional landscaping to offset the selective removal of trees for sightlines may be required by the zoning administrator. So you could have a situation where someone wanted to do some daylighting for any number of reasons. It could be site distance easements, it could be for aesthetics, but then those trees may have to be planted somewhere else to offset any impact. And then down in item 10, the removal of the planning commission. And then we jump over to section 11, zoning amendments. And this is an excerpt from Article 15, 16, 17, section 11, zoning amendments. And there was a typo in the ordinance. If you come down to B, as you see on the screen there, it says by adoption by the planning commission of a motion versus a resolution of intention to propose an amendment. So that's the initiation of amendments to the zoning ordinance. And if you turn over on the next page, it reduces the number of copies needed for a generalized development plan from 21 down to 15. And then continuing on to section 13, use permits. And then we move over to section F, submission requirements. Then under F5, again, we reduced the number of plans that need to be submitted or GDPs that need to be submitted from 21 down to 15. And then finally, in the last section, excerpts from the amendments in section 2.1, uses not provided for. It says a property owner may petition the Board of Supervisors for an additional use that is not specifically listed by submitting an application and narrative detailing the requested amendment to the zoning administrator. The zoning administrator shall refer the application to the planning commission, which shall make a recommendation to the board. If the application is approved, the Board of Supervisors, by the Board of Supervisors, the ordinance shall be amended to add the specific use. And so this is just to clarify what needs to be submitted in that instance. And so a narrative and a detailing, the requested amendment. So those are the changes to the zoning ordinance at this point. Like I said, most except for the environmental section on stockpiles are mandated by the Code of Virginia. And the cleanup items that changed motion to resolution and added this clarifying language were precipitated by changes to the state code. So I'm happy to answer any questions if you have any.
Commissioners, any questions? There being no questions, is there any further discussion amongst the commissioners? If not, is there a motion regarding,
Open the public hearing, sir.
oh, that's right. Public hearing regarding text amendment 03-2025 is now open. Any person having interest or desiring to speak, please come forward. Anyone wishing to speak, please come forward. Final call, anyone wishing to speak regarding this matter, please come forward. Seeing and hearing no one come forward, the public hearing is now closed. Commissioners, what be your pleasure regarding text amendment 03-2025? Motion by Mr. Williams, seconded by Mr. Young.
Mr. Chair,
Sir,
does that motion include with the proposed changes?
yes,
to
with the
definitions?
proposed changes as presented. Motion by Mr. Williams, seconded by Mr. Young. All those in favor signify by saying aye.
Aye.
All those opposed, nay. The ayes have it. Motion carries. All right, that brings us to any and all matters.
So we don't have any and all matters tonight.
Thank you, sir. Commissioners, the chair will gladly entertain a motion to adjourn till our November 20th, 2025 meeting.
I so move, we close the meeting of this board until our next stated meeting.
Motion by Mr. Tingler, seconded by Mr. Young. All those in favor signify by saying aye.
Aye.
Boy, that was loud and clear. I will tell you. All those opposed, nay. The ayes have it. Motion carries. This meeting is adjourned. Thank you, one and all.